Hi, everybody. Welcome to Help Solve the Case. This is Christine Burke, retired police detective, sergeant, law enforcement expert, forensic genetic genealogist, and investigator. And it's continued to be continued, but not today. I'm going to give you the results, my review from day 5 of the Tyler Robinson preliminary hearing. But spoiler alert, it is continued until September 1st at 10 a.m. What does that mean? It sounds like we don't have any more information until then. So we're going to have to speculate. We're going to have to hash it out ourselves. And we're going to have to see what we can glean from the information presented. But let's get to day 5. So this is my commentary. I have my notes. First of all, thank you for being here. Thank you for liking, sharing, and subscribing. We have almost reached our goal. You guys are wonderful of reaching 1,000 subscribers at minimum. The day started out with a boo-boo by the camera people, what sounded like portions of Tyler's note, not sure. They were referencing that it was already in a search warrant, that the full text was in a search warrant filed September 17th in a different court, and that some of it was referenced in the information, which was the filing document. They were going back and forth, so we lost our ability, at least at this portion. Sorry, as I flip my page, we lost our ability to see the documents, okay? And the defense popped up and said, Your Honor, this is not the first time that this has happened, and the defense doesn't want the cameras in the courtroom. So they might duke it out between now and then. We had a lot of the media attorneys there, the attorneys for Erica Kirk, the victims' attorneys, victims' families' attorneys, and they just want to get this done. So we'll see what happens between now and September, okay? The state stepped up pretty much immediately and was talking about the discussions. You know, we wasted a lot of time having arguments back and forth. Although we do want to say that, you know, if you were on the team that needed to argue, we certainly want your attorney to have the right to be heard. And I think the judge was pretty good about that. The attorneys were very respectful, and boy, did they say their piece. Okay, so that is what we want them to be able to do. But the state did point out, as I read in my video yesterday about the probable cause, that the state has the court has to weigh the evidence in the favor of the state. So I think it's pretty much a foregone conclusion that he's going to be bound over for trial, but we'll see. All right. They were talking, the state was talking about, I talk about wording and semantics, that the evidence was so contradictory, unbelievable, wholly lacking, right? Talking about what the defense was asserting, and that though there's such a low bar for being bound over in the preliminary hearing, that even recantation by a victim may be insufficient. Okay, I thought that was interesting. And the state said quote, the evidence is overwhelming. It's devastating. And maybe I should have put that on the thumbnail. I'm not sure. Okay. And that was, is it Grulander? Not sure. Not catching all the names. Okay. Bear with me, folks. So our first witness was Caitlin Oliver, who was put on by the defense. Okay. This is a government employee from the Bureau of Alcohol, Tobacco, and Firearms who typically should testify for the prosecution. Okay. Just FYI. And she is the DNA section chief. She's been doing that since January. She's been at the ATF for 9 years. She's a prior forensic biologist, which means having her hand on the DNA. And previous to that, she worked for the Jefferson Parish, Louisiana Sheriff's Office. And she was a forensic biologist in September of 2025. Now, the DNA, she said she received DNA, which was work from the state of Utah on September 11th 2025. And we had some things with muting. Again, it's a little hard with the discrepancies between what we're supposed to see. I think they thought we weren't supposed to hear it. And so we lost part of it. But it started about talking about some document. I think it was 1.2. I'm not sure because, like I said, we got muted. And they're talking about these calculations, how they're coming to their decisions about the DNA analysis. We'll just say that, okay? And so they were talking about here about item F or subsection F, that it says, quote, based on this calculation, there is evidentiary support for the inclusion of Tyler Robinson, okay? And she's correct, as a possible contributor, okay? So then the defense is honing in on, here's our semantics, right? Legal interpretation. He's like, what is, quote, evidentiary support? And talked about how a prior witness testified to a scale and used those words, right? So what does that mean? What does evidentiary support? So we've got the FBI person that was there talking about their interpretation. Remember, we had the DOJ, those guidelines about what they can say and what they can't say and how they're supposed to report it. And now we have the ATF, which is also a federal agency, which is under the same DOJ guidelines. So they're going to see what this lady has to say about her interpretation and how she prepares her stuff, right? So he says, does your agency use that? And she says, quote, we can come to 5 conclusions, right? So let me back up a bit. The defense was referencing the language from the prior analyst that was saying strong support, very strong support, that language when they went through those things. And so, because, they're limited on what they can say by this document. So the defense is saying, well, does your agency use the same system? So she says, we can come to 5 conclusions. There can be either exclusion, limited support for exclusion, uninformative, limited support for inclusion, and support for inclusion. And the defense says you don't use the qualifiers like strongly, very strong, and those sort of things. And she says, quote, yes, we don't use a verbal scale at our laboratory. So I thought that was interesting. Why is what, right? They're limited, right? I know this is my soapbox. Why are they limited on what they can say? And then they've got this document, but still they're supposed to have this document for uniformity, right? But now one is used in one scale and one is not used in the same scale. And why are they saying things differently? Okay. So the defense says, is that a scientific phrase when you say, instead of saying support for, strong support, right? He's asking, is that a scientific language? So she says, quote, so our laboratory doesn't use a verbal scale due to the fact that they add subjective words, keyword there, subjective words, to the front of the word support. It is our stance that the likelihood ratios, statistics, the number stands on its own. So we report the likelihood ratio and either support for inclusion or support for exclusion, okay? So remember, when we had the FBI testifying, we had those octillions and quintillions, and we also had the, very strong support, and those qualifier words. So now, this lady's saying, no, at the ATF, we can only use exclusion, limited support for exclusion, uninformative, limited support for inclusion, and support for inclusion. Again, completely different verbiage, right? And words matter. Words are important. The state said it, remember? Okay. So she says that they don't use subjective words. Well, what is subjective? It's subjective. It's subjective. So they don't use those words. Interesting, right? Hopefully, I find it very interesting. Okay. So, what she's saying is they don't need to say very strong support or strong support. They just either say, basically included or excluded, because she says the statistic, the number stands on its own. So he stated the conclusions conform with the relevant Department of Justice policy on uniform language. And she said correct. So he asked, why do you include it? And she says she adheres to the DOJ ultra statement. Okay. And I'm thinking I pulled them up. Maybe we need to go over those because they seem to be tossed around a lot. And I know we're going to see them at the trial. And this may be informative. If you want me to do that, let me know. It may be informative at some other trials because I'm sure which somebody noted in the comments, thank you, the feds seem to be getting involved in all kinds of cases. We need to know this, right? And again, my bone to pick here is I don't like these experts being limited in what they can say and what they can't say. And I referenced this with the forensic genetic genealogy. You should not be hampered or limited in doing the job that you need to do, right? I'm not on one side or the other. I can see it on the cop side and I can see it on the defense side. Like, we just want a freaking answer, right? I don't think we should be worried about who sounds more proper than the other person. I want the answer, right? What did I say yesterday? The girl said the ground truth. I want the ground truth. I don't want, what is it, pejorative language or whatever. I don't want that. I just want the freaking number. And you'll hear more about the numbers as we go on. Okay. So then he starts talking about the other document, the one about probabilistic genotyping. And he starts asking her, what is your understanding of the qualifications and limitations, right? So what does the policy tell you can do or not do? He says, well, what are you not supposed to say? So she says, well, there's a few things. If you use a verbal scale, which we do not, then you need to use the one in the document. This is an effort to unify the language coming out of the DOJ laboratories. Right there. Listen to this. This is an effort to unify the language coming out of the DOJ laboratories, but one uses it and one doesn't. Okay. She says, it also says that we cannot say that evidence is infallible, nor can we state that there is an inconclusive result. Okay, so that means that our evidence is infallible. Okay, so they're saying that they can't say that they can't get it wrong, and they can't say there's an inconclusive result. So that means they have to make a determination no matter what. Do you get that, what they're saying there? So inconclusive means I don't know. So they can't say, I don't know. I mean, that's what I'm understanding this. So I was trained when I did court testimony to say, I don't know. Like, if you don't know, you say, I don't know. You don't make something else up. But it sounds to me like they can't say they don't know. Inconclusive. Okay? I don't know. He also asked about the zero error rate. Remember, we heard that with the FBI lady. That's in the DNA video. Along with the absolute identification or source attribution to an evidentiary sample, meaning linking a person to an item of evidence. The defense also is asking her, so you shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to a sample. Okay, correct. Okay, so just because there's a magnificent ratio, they can't say that that's an absolute ID, nor can they say that they can't attribute any person to a sample. Okay. But remember, we talked about in the DNA video with the FBI lady that when it comes to elimination, that can be a person, but when it comes to evidence, that can't be a person. Remember that? If you haven't watched that, please go watch it. Okay. So the defense confirms. So nothing is asserting absolute identification because we're seeing these quintillions, octillions, trillions, all these huge numbers, okay? She says correct, quote, correct. With forensic evidence, it's impossible to state with 100% certainty anything. That's the sentence. That's why we report a likelihood ratio to speak to that uncertainty with a statistic. So they're going to speak to uncertainty with a statistic. Now, I'm playing with the words here, semantics for a reason here. They can't say inconclusive, but what did she just say here? And I'm asking you guys, are you here? I know you're hearing this instead of reading it. I apologize, but maybe we can go through the document. You know, I'm more visual than auditory, but I apologize. You can't read my handwriting anyway. But remember, she can't say inconclusive, right? But she says, that's why we report a likelihood ratio to speak to that uncertainty with a statistic. Is there a statistical level of uncertainty? Did you get what that does? Like, okay. So then he says you can't use, remember the words science to a reasonable degree of scientific certainty and stuff. She says, no, we can't use those words either. Then he asked her when she received the assignment. She said she didn't know. She'd have to look at her case notes. And he's like, do you want to refer to them? And she said, I don't have them. I'll leave that there. Then he started asking about permission to consume. And we talked about that with the FBI lady, right? And she says, yes, she has to get permission to consume. And he referenced an email in the case file, apparently, because he had the case file. She did not. So he's asking about an email. So she apparently sent an email to request permission to consume all of the DNA. And she said, quote, it's standard procedure at our laboratory that when we receive a case, we request permission to consume from the agent, end quote. Agents, do you understand what you're doing here? Okay. I'm not sure. I don't know, but I'm not sure I agree with this blanket. Well, we're just going to ask to use it all. You know, we bought this whole chicken for the family and I'm just going to request permission to eat the whole dang thing myself. I mean, I don't know. Okay. I'm continuing on. Quote, we request that they reach out to an attorney if one is assigned. In this case, we will not begin any work on the case until we've received that permission to consume. So it doesn't matter what the attorney's going to say anyway. Apparently, right? Because they're not going to work on the case unless you get the permission. So is that really voluntary? Or is that just, we're going to do it anyway? I'm just asking. Semantics, okay? Then he asked, this is the defense attorney, does your lab have a policy to preserve for the defense? She says, quote, where possible, we will not consume samples where it's possible. But they're going to get permission anyway. You know what that sounds to me? That sounds like, you know, if at first you don't get it, just keep on going until you get it. Or we're not going to be particular, or we're going to be, you know, we're just going to take the whole freaking thing anyway. And just that way we don't have to worry about it. You know, I don't have to worry about being selective. I don't know. I'm not a biologist, but that rubs me the wrong way. Okay. Right? Because when it's gone, it's gone. Can't you be selective in this day and age about what you take and what you don't take? And can't you collect the sample better so that you have more samples? I mean, okay, I got to talk here. I had a case and they had a thing that was 56 inches long. And they took one swab from one tiny portion of it and not the rest of the 55 and 9/12 of the thing. And then they were like, we don't have DNA. It's like, get your Q-tips, okay, and start to swabbing because you got, right, 55 inches of potential. And I hate it, no offense to my lab partners, when I'm expecting that you went to the moon to look for every possible biological sample and you didn't test the whole dang thing for me. I'm expecting you like when something happens in the cavalry, you need the cavalry and all the cops come running. Betcha I'm expecting you to scrape every known piece of value off that dang thing. I don't care how many Q-tips it takes, especially in a murder case or a violent crime case or a sexual assault case. Sorry, that's another soapbox. But man, I'm tired of hearing we don't have anything. And you better, scrape that thing to death. You better burn out every Q-tip in the lab. That's just my thing. Okay. So going back to this consumption, the defense says that policy is a longstanding policy, not only in your lab, but in forensic DNA communities and labs across the United States, right? To not consume. He was talking about not consume. And she says, correct. He says, this goes back to, he's going to whip out his reports and his books now again, right? So he says, this goes back to 1996 when the NRC recommended the policy of splitting at the front end of the analysis, meaning saving half. And she says, quote, where possible, yes, end quote. But remember, they don't work unless they can use the whole thing. So he asked, right? So the defense asked, they did that, meaning they recommended this, NRC recommended the splitting, and he's asking her. So they recommended that because it was their conclusion that the best insurance against a person being falsely incriminated is the opportunity to have the testing repeated, right? She says yes, but they don't work on it unless they can have the whole thing. So he starts getting into, were certain items consumed? Yes. Which ones were consumed? 1.4, 1.6, 1.9, 1.10, 1.12, 2.1, 3.1, 4.1, and 5.1. Then he talked about DNA extract or DNA liquid being preserved. And that was only on 1.1, 1.2, 1.3, 1.5, 1.7, 1.8, 1.13, 7.1, and 8.1. And they consumed the swab, so they only have the extract. And I don't know what those items are. If we get a list of those items, or maybe we can pull it off of the court video, or we have those reports somewhere, we can see what is left to work with at any. So then the defense says, were all the samples mixed? And she says, with the exception of the known people, so we know who those are, evidence samples were all mixtures. Okay, and we know mixtures can be problematic. The defense says, well, yes, they were mostly 4 or 5 people. Yes, yes. And they break that out into major and minor. Yes. So he says, defense says, well, let me ask you that with this major contributor, minor contributor. Is that meant to convey an activity level. For example, that because there's major DNA, the major contributor was involved with any activity or the most activity. And she says, quote, "None of the testing I performed could speak to activity or what activity led to the deposition, the deposit of DNA," end quote. Okay. So he says, defense, this person is that this person is a major contributor says nothing about the person's activity related to the item. And she says, correct. So then he's going back to these policies and saying, are there, oh, hold on one second. Sorry. The bat phone was going off. Okay. So we were talking about, more limitations with the report, what they can report on. And now he brings out this NIST, right? We talked about this NIST study, the forensic DNA interpretation and human factors. He says, quote, "What to say and what not to say," end quote. And he asked her about it. And she says, "I don't know." He was asking her if it was a guidance document, like what to do, right? What to say, what not to say. And she says, "I don't know that I would call it a guidance document. NIST is not a regulatory body for DNA testing. It was a report that looked into forensic DNA reporting and specific human factors that can affect our testing. So they may have had recommendations, but as far as them having a regulatory body issuing guidelines, I wouldn't state that." So, do you think when stuff like this happens, work, right, that needs to be done in criminal cases or otherwise, that it should only be a regulatory body issuing guidelines, or can other people issue guidelines? Just asking. So, the defense says, well, NIST has some recommendations and caveats, right? Because she said, I wouldn't call it guidelines. So he starts talking to her about these recommendations. For instance, how to describe contributors. And he says, they say, NIST, quote, "The true number of contributors of DNA to an item can never be known," end quote. And she says, correct. So think about that, because we've talked about, specifically in the DNA video, but dialing it in, the human factor, right? Because this is a report about human factors and DNA. And again, not on one side or the other, but just looking at this process and how it comes to be and how it's represented in the criminal cases. So we got somebody that, and I'm cranking on a dial, I don't know how it's done, 2 people, 3 people, whatever, 4 people. The person has to tell the machine what is coming in and what is coming out, right? The HD and the HP. And the person has to look at the peaks on the electrophoregram and decide how many contributors, right? Because you need the contributors to get the number, right? You need to know who's present. But this NIST caveat right here says the true number of contributors on a DNA to an item can never be known. Ever. And she says correct. So what does that tell us? Right? Fallible, right? Then he asked her about a reporting cap. And she says, yes, we cap at 1 trillion. The actual number can be higher. And what are they talking about? Remember, the FBI person had quintillion and octillion, whatever those numbers are. And she says ATF caps it. Okay, they use a reporting cap. Remember when I read them? It was 1 trillion, 1 trillion, 1 trillion, 1 trillion, 1 trillion. So she says, quote, "We choose 1 trillion because it has meaning to people. They can understand what a trillion is. An octillion and a quintillion gets a little high at that point, so we cap at 1 trillion, end quote. So let me ask you, do you want to see if it's an octillion? I don't even, sextillion, like I don't even know how those numbers go, but do you want to see, and just don't kill me on the language here, but do you want to see the real number or do you want to see it capped? And I know that, real versus fake and people are talking about this case, but I'm just saying, do you want to see, let's use this word, do you want to see the actual number or do you want to see a capped number? I would like to see an actual number. I don't want to see a capped number. Just like I want to hear the actual analyst's opinion, not only what they're allowed to say. We're just having a discussion here. So then he says that the policy tells you how to report the cap. Okay. And he says, I guess that, I don't know if that's in the NIST report or the SOP. I apologize. He says, they say, quote, the LR, that's the likelihood ratio, reporting cap was chosen because of the limitation of biostatistical modeling and independent assumption of STR loci, end quote. So she says, yes, we chose for the reason that she gave. Okay, let me get into this because this is important. So the industry is saying, this NIST, the likelihood ratio reporting cap was chosen because of the limitations of biostatistical modeling and independent assumption of STR loci. So they're talking about the analyst, the limitations of biostatistical modeling and the independent assumptions, there's that word, of STR loci. That's why NIST is saying that they're the reporting cap. Okay. She's saying, no. We chose because 1 trillion has meaning for people, not octillion or quintillion. I'll leave that dead horse there. Okay. So he asks her if she agrees or disagrees, and she says she's not familiar with that publication. Then this NIST document also suggests, the defense is saying, okay, so this NIST document also suggests putting an alert in a report that profile descriptors can't be applied to activity level. Okay, says here, profile descriptors cannot be applied to activity level issues, and she agrees. And she says, yes, this is what you were stating about calling a major contributor. It doesn't speak to the activity that led to the DNA deposition, the DNA deposit, okay? So I thought this was very important here. That just because somebody is a major contributor does not mean that they had more or less activity. Okay, and remember, we can't tie the DNA being there to a certain activity. For instance, for example, just because somebody's DNA is on a gun doesn't mean they touched the gun or shot the gun. And we're going to get into that a little bit, okay? So the defense attorney here, right, he's reading it, he says, quote, DNA profiles may be described as major or minor. However, these should not be interpreted in the context of a decision regarding the nature or the mechanisms, action, timing, or the deposition of the DNA. Okay, let me read that again. the use of major or minor in the context of a decision regarding the nature or the mechanism's action, timing, or the deposition of the DNA. So the major or the minor has nothing to do with action, timing, or the deposit of the DNA, how it got there. And she agreed. Okay. So he says, does this quote convey that the DNA results cannot be interpreted by the analyst providing an opinion regarding who the source of the DNA is, end quote. She says, quote, yes. So this is, once again, we don't make source attribution, meaning who put the DNA on the pen? Somebody that used the pen, or did it get there some other way? She says, we will say there is support for inclusion, and then we back up that with a statistic, okay? Let me back up. Okay. Sorry, 1 second. Hold on. Okay. So defense asks, so from a scientific standpoint, you could not read the paragraph that sets out the likelihood ratio in your report, whatever the number, and then blast a headline in the media, quote, Mr. Robinson's DNA is found on this item, end quote. That's a source attribution, is it not? Okay. And she says, correct, yes. So just because there's a statistical inclusion, she can't say, and here's the example, Mr. Robinson's DNA is found on this item. So in this case, we have seen 1.7, was it octillion and 30 quadrillion likelihood for certain items? Well, the analyst can't say that that is his DNA on that item. So what does that report mean for us? How are we analyzing that report? Okay. And then he says, and that would not be scientifically defensible, would it? To say that. And she says, correct. And I know this is a lot of wording and a lot of semantics, but I think this is very important about how the defense is going to present their challenges about the interpretation of the reports from the state agents. And they're making some good points about the limitations. Again, just like the media attorneys and the people are saying, we want to see this, we need to see this. Is this acceptable that they're using these caps and you can't say this and you can't say that and you can't count the number of contributors and this person does this and this person does that? Are we okay with that? So the defense says, and I'm almost done, the defense says the likelihood ratios cannot speak to the likelihood of a proposition, only the probability of the results given a pair of propositions. And that is like, so the likelihood of a proposition, no, it's only the probability between two propositions. Like, goodness gracious. So she says, quote, remember, we're talking about these likelihood ratios, the octillion, the quadrillion, and the 1 trillion. And she says, quote, so a likelihood ratio statistic compares the probability of the DNA profile of the evidence given two competing hypotheses or two competing scenarios. Typically, the first is that the person of interest is an individual, and exclusionary hypotheses that the person of interest is excluded. So there's a random, unknown, or unrelated individual contributing. So it's just the person of interest is included, or there's a random or unrelated individual contributing. Like that's it. It's like, it just sounds like random statistics, doesn't it? The defense says, okay, they elaborate, quote, and I know that this is words. I wish I had it written out for you. A likelihood ratio indicates if and to what extent the DNA analyst's results support one proposition over another. It is not possible on this basis alone to determine which is the most probable proposition. Do you hear that? A likelihood ratio indicates if and to what extent the DNA analyst's results support one proposition over another. It is okay. So we have one that's going to be the quadrillion or whatever, and one that is not, right? It is not possible on this basis alone to determine which is the most probable proposition. So that sounds to me, am I reading that wrong? That just because you have one that says 1.7 octillion and you have one that says 0, it is not possible on this basis alone to determine which is the most probable proposition. I mean, goodness gracious. Okay. So then he talks about that that they want to convey that DNA statistics cannot imply uniqueness within a population. Okay, so just because there's an astronomical number there doesn't mean that there is uniqueness in a population. Well, what is uniqueness? Only one. So then he's asking, does this go back to the source, right? Does this statistic mean that it's tied to the source? And no, you can't say that. She said correct. And he says none of the testing can answer the question of how and when the DNA was deposited. And she says, quote, that's true. DNA can't speak to the activity that led to the deposition of the DNA, the depositing of the DNA. And the defense says, with the increased sensitivity for DNA techniques and sophisticated software, a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swabbed. Alternatively, a person's DNA may be present when they were not involved in the crime. Do you want to read that again? With the increased sensitivity for DNA techniques and sophisticated software, a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swabbed. Alternatively, a person's DNA may be present when they were not involved in the crime. So she said yes. So he says, how can a profile be developed when the item was not touched? So she says, quote, it's possible if, say, the pen you're using for a week, you say, hand it off to the judge, and the judge then touches it for a period of time, and then I swab it. It doesn't speak to who handled it last. I could say that, or she said, I could test that. I could get both of your profiles. I wouldn't know which person was the last person to handle that item. And she also talks about touch DNA, transfer DNA. So he says, defense says, if you had a lot of DNA and you shook hands and I touch a gun, it's possible that your DNA would be on the trigger. Okay, so he's talking about him, the defense attorney, shaking hands with the witness, and then the defense attorney touches the gun and the trigger, and then they swab it, and then her DNA turns up on the trigger. It's transfer DNA. She never touched the gun. She touched his hand, which then touched the gun. Think about that, okay? And the defense says, and that's why we can't determine how or when the DNA got there. Then he starts asking about DNA degradation, and she says that DNA is quite stable, but heat and humidity can break it down. She doesn't have an exact time or method or anything to outline that. So then he asks, he says, there was degradation in the DNA, right? And she called it, quote, environmental insult, end quote. He then, defense brought up the Dremel and asked if she requested elimination samples. And she said, quote, asked her what an elimination sample was. And she said, quote, an elimination sample is a sample taken from a known individual that may be assumed, there's that word again, that they could have come into contact with it. For example, your car. If your car gets stolen, she would request an elimination sample from you because you are normally in your car. The defense said, you mean like, quote, assumed contributors, like in a house, and samples from all people in the house? She said, yes, okay. So he also asked, and I remember raising this, right, because we had so many contributors. Remember the towel and the gun? Remember that little back and forth about who touched the towel? Did they pull the towel off first? Who touched the gun? Did they touch the gun without the towel? Whatever. And remember, on a lot of the items, we had 4 or 5 contributors. And I was like, well, who are the other contributors? Because they would have done their elimination samples, right? So who are these other people? And I said, did they test the agents? Well, guess what? Defense says, you requested samples from agents, but you did not receive them. She says, correct. She said, because the technology is so sensitive that it's, quote, standard practice, end quote, to get investigative samples. But she got none. She did request and get samples from Amber Robinson, mother, Matthew Robinson, mother, and Lance Twiggs, roommate. She said that she determined their profiles and then compared them. The defense said, you found DNA of elimination on some of the items. And she said, I found, quote, support for inclusion for some of these individuals, meaning Amber, Matthew, and Lance. So they got into specifics. 1.4, the rifle. Tyler's father, his DNA was on the bolt. She said it was, quote, support for inclusion, end quote, as a, quote, possible contributor, end quote. And that there would be a statistic, that number, that huge number associated with it, but we didn't see that. They talked about item 1.6, which maybe, it was very hard to tell because they were talking and we didn't get to see the documents, might be the buttons of the Dremel. And Lance Twiggs, 1.6, whatever that was, the father, Tyler Robinson's father's DNA is on there. And she said, again, we would have support for inclusion, end quote. Then the buttons of the Dremel, I don't know what number that is, and other areas, there was support for inclusion of Lance Twiggs. Then he started talking about next generation sequencing. She said it was a newer technique. And I thought it was very interesting because he asked if, next generation sequencing is what I use, forensic genetic genealogy. And I have heard ad nauseum about how the FBI is the best one in the business and they should have all this DNA from certain cases that are around my area, blah, 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 blah. Private labs, blah, 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 blah. Sorry, another soapbox. And so he asked, is next generation sequencing being done by the ATF? And she said, not by the ATF at this time. And I thought that was very interesting. And then he asked her, well, do you know of any other lab that is doing it? And she said, maybe some labs in the United States, but I don't have any knowledge. So I'm going to follow up on that because what you're hearing may not be what you think it is. Okay. So he started asking her about this STR mix NGS. She said she wasn't aware of what that was. He started talking about with next generation sequencing, how it sequences the whole genome, which we know. And he started talking about how in the STR testing, right, that measures the length, remember they talked about the boxcars, that it doesn't measure the sequences inside, it only mentions the length of the boxcars. And he was talking to her about the fact that they have found, which is kind of scary, that the sequences can be different inside the boxcar. So even though they're measuring a 7, let's say, there could be differences within the sequences. And he started going into this about the D3 location with the number 17 allele. And how there can be differences there, 17A, 17B, 17C, and the state got up and they started objecting, saying it was too much for the preliminary hearing. They talked about that different locations with the loci. She was just like, she didn't do this, so she can't draw conclusions. They were talking about if it fails to match, do you declare it just as a not match? And she said, no, it's not quite that simple. There can be degradation. It could drop out. And so she couldn't have an inclusion or an exclusion. So basically, if something's missing, if it fails to match, she's not going to call it anything. So then he asked, could this be an exclusion if the testing wasn't done? And they kind of went back and forth on that. And then they started talking about contributors. And again, I know this is like, we've heard this, but this is very interesting. And I think it's very important because it's subjective. It goes to the determination, in my opinion, my expert opinion, it goes to the determination that the expert has to make, of which they're not allowed to talk about, right? And they have these policies, okay? So they have input and decisions that they make about these things of the number of contributors and stuff, okay? So then he was talking about that statistical number, remember? And we heard from the FBI that depending on the number of contributors that you dial in, it can change that number, right? That's what I thought I heard. So here she says, no, that doesn't necessarily relate to the number of contributors. It's not correlated with the number of contributors. And she said, so defense asked, a likelihood ratio numeric value is not a measurement of a physical quantity, which I thought was interesting because I think us, when we hear a large number, like 8 ounces versus 1 ounce, we think 8 ounces, that's a bigger quantity. And he said a likelihood ratio numeric value is not a measurement of a physical quantity. So even though we have the octillion and the quintillion, it's not telling us how much DNA was present. Okay, so it's not a full cup. It's just a probability. So he says, rather, it is a ratio of probabilities in the opinion of the expert, again, subjective, in the opinion of the expert, assessing the likelihood ratio and is dependent on the specific propositions. Remember those HD and HP used to formulate it, and also on the individual making the assessment. Subjective, subjective, subjective. He also asks, is the final ratio dependent on the number of contributors you assume? And she says it can or it can't be. He also asked, is it difficult to figure out the number of contributors? And again, he's asking this because most of the items have 4 or 5 contributors. And that is, from my understanding, a very tough mixture. So she didn't really answer that. She said she uses her training, education, and experience. And then he talked about, quote, the profile consistent with at least 5 contributors, at least one of which is male. That was referring to a result. And he said, when you use, quote, at least, you're signaling it could be more. Because remember, we talked about earlier, you never can, and she agreed, you never can 100% estimate the number of contributors. So he asked, as contributors increase, difficulty increases, right? And then he starts referring to her standard operating procedure manual. And they have specific guidance for 3-person mixtures. And he starts reading this statistic. And I don't know if this is from her manual or from the NIST thing or what, but this is an interesting statistic. He says, okay, you ready? Approximately 70% of 4-person mixtures present as 2 or 3-person mixtures based solely on number of alleles present. Okay, let me read that again, right? Because we had 2 and 3-person mixtures with the major contributor, and we've had 4 and 5-person mixtures, okay? So if we have, okay, let me read this again. Approximately 70% of 4-person mixtures present as 2 or 3-person mixtures based solely on the number of alleles present. And she agreed it's possible. So if we had, and I thought we had this in the case, maybe not, we had a 2-person mixture, which was Robinson and Twiggs, we're just using it as an example. And that was identified as a 2-person mixture. If 70% of a 4-person mixture presents as a 2 or 3-person mixture, is that 2-person mixture really a 4-person mixture? Remember, the FBI person said she first thought it was a 3-person mixture, didn't she? She thought it was a 3, and then her technical lead agreed, and then they went down to 2. So was it really a 3-person mixture? Very interesting statistic here, right? So then the state objected, again, about the preliminary thing here. I'm just looking. Okay. So then the state came back to cross-examination, and she said, the state asked, where on the firearm did you find evidentiary support for inclusion of Tyler Robinson? So she said on the rifle, because I don't know if we knew all these areas, stock and grip, the butt plate, the trigger and the trigger guard, the bolt, the fore end, the barrel, the optical accessory, and I didn't hear this one before, the underside of the receiver, which was protected and it had to be disassembled, and 1 30-06 casing and 2 30-06 cartridges. Then he went through the numbers about the trigger and the trigger guard, where it was the 1 trillion. We read these yesterday, with Tyler Robinson being the major contributor, rather than 4 unrelated people. And they went through, again, I'm not going to go through all this stuff, but the defense came back and said, on the swabs of the trigger and trigger guard, which were swabbed together, okay, which means they took, okay, the trigger and the trigger guard, they took either 1 Q-tip and swabbed both areas at the same time, or they took 2 Q-tips and swabbed one and then swabbed the other and mixed it together. Okay, so trigger guard and trigger, two different pieces, All right. They blended it together. And the defense pointed out that it was degraded. Okay. Why does it degrade? We've heard heat and humidity. We've heard environmental insults, all that stuff, and that there were 4 contributors. And when he asked, he said, did the major contributor have the most degradation? Yes. And could she tell when it was deposited? No. And because we never truly know how many contributors, could it be 5, 6, or 7 people? She said yes. He reminded us just because Tyler Robinson is listed as the major contributor, it has nothing to do with whether he was involved in any activity. Okay. And the defense mentioned that some of the items in the case have major contributors of more than one person. And we think that it was on the stock of the weapon. So, holy moly, there we are. And we're continued until September 1st. So, I'm going to take a deep dive into all this stuff. I'm going to look at some of those documents. Maybe I'll do videos. We're continued until September unless some intermediate filings go on. Thank you, thank you, thank you for being here. I don't mean to belabor these points, but this wording is absolutely essential in the way that they are able to explain this wording and what these processes, how these processes take place, limitations to the jury eventually, or using these wordings in preliminary motions, right? I feel he's going to be bound over in pretrial motions, arguing constitutional issues, okay? And the state did say, look, all this stuff, trial fine, not right now, okay? But we're postponed until September 1st. So if you have any questions, please feel free to drop your questions, pop stuff in the community. I'm going to try to look at those DOJ documents. I'm going to prepare. I'm going to go through all the evidence that we looked at and try to provide a nice summary video for you. And anything else that you think that you want me to look at with regards to this case, please feel free to forward it over. So excited to have you guys here. We are so close to the goal, and I just truly appreciate you. And I allow you to come into your home, come into your phone, come into your car, come into your workout, and just share what I love talking about. All right. I will see you on the next video.